Hey, everybody. This is Chuck Cook here, managing partner at Cook Baxter. Look, I've got it in Spanish. I need to probably change that banner a little bit, change my name a little bit here. I wonder why it says that. Anyway, it's great to be with you today. Now, today's in English. If you have a Spanish question, si tiene pregunta en español, lo voy a contestar. But usually today we're going to focus on English because today I want to talk about something that is a really, really big deal. A really big deal. In 18 days, 19 days, says the 12th, right? And it's 13th, so 19 days. The big USCIS money grab begins. That's right. The USCIS is raising their fees, and the money grab begins. Put a little banner up here. Money grab begins on April 1. So let's add that banner in here. USCIS money grab begins on April 1. Chuck, come on. I mean, really, the government has to make money somehow. I mean, really, how can they not make money? They've got to be able to make money. Well, it's government, right? Why is this funded by taxpayer dollars? Now, let's start out with the basics. The USCIS part of immigration is, for the most part, funded by user fees. That means you, the client, you, the foreign national. If you want something from the Immigration Service, the USCIS, you have to give them money in exchange for that. And in return, they promise nothing. Nothing. They promise nothing. In fact, they told a federal court judge recently in our interpretation of that, we never have to make a decision, Judge. You can't force us to make a decision. And we don't ever have to make one if we don't want to. So in return for you giving them money, they never have to do anything. Now, generally speaking, they do. But looking at the Immigration Service today, sitting on over a 9 million case backlog, biggest backlog in history, despite what they lied about last month, that they had reduced the backlog last year. That's literally not true. From their own statistics, they had 500,000 more cases pending in front of them. So what we're really looking at here is the Immigration Service trying to, I can't say balance its budget, but at least to fund itself on the backs of immigrants, Now, these new filing fees are, they're all over the board for 2024 for USCIS. Let's take a look at some of these. For example, right now, we'll get into H-1Bs in a second, but it's H-1B filing season for the lottery, and the H-1Bs, the new filing fee for the H-1B is going to be going up. Filing fees for green cards are going to go up. So let's take a look at some of these employment-based cases. So the new fee for an H-1B goes from $460 to $780. So it's about an 80% fee increase. That's the base fee. Okay, there are another $1,500 of statutory fees on top of that. So really, what you're looking at is a filing fee now approaching $3,000 for a large company, for a company that's got more than 25 employees. These $2,500, $3,000 per applicant. Now, immigration says it only takes them about an hour to do an H-1B. So that's a pretty good hourly rate. I mean, if you can get $3,000 an hour, that's pretty good money. Let's see. Now, if you're going to file an I-140, here's the weird thing. I-140s, which include things like extraordinary ability, which can be very complicated, they're raising by $15. They're going from $700 to $715. Why does one go up 80% and the other goes up basically like 2%? Why? That's a great question. O1s are going from 460 to 1,055. It is a 120% fee increase. Now, if your case is postmarked by March 31st and they received after, you pay the old fee. So obviously, if you want to get something done, you want to do it now. Else, which are going from 460 to 1,395, that is almost a 200% fee increase. 200%. Why? Well, Chuck, come on, these are really complicated cases. They just take a long time. Well, let's say it takes them, 2.5 hours to do an L1. All right. But your hourly rate is $500 an hour? That's what you're charging? Now, clearly, and by the way, on top of all that, for certain clients, they're going to add an asylum fee. So you're going to pay extra money. They're going to try to pay for asylum because asylum applicants don't get charged, at least right now. So in order to do those cases, which are incredibly time consuming, I mean, those take 8, 10, 12, 20 hours of time each. And there's a million of them, or more than a million of them. They're hopelessly behind. They'll never get to them. They're just never going to get to them. It's not. They're never going to get to them. Not in my lifetime, anyway. So they're doubling these fees on the back of employers. They're doubling the fees. Now, what I want to talk about today, actually, I mean, that's awful, but at least it's employers, right? Presume the government's like, well, they can afford it. They're businesses. Like businesses are made out of money, which they're not if immigration ever talked to a small business owner. But why would immigration care? They don't care. They really don't care. All they care about is the money. Now, here's what's truly disturbing. Truly disturbing. In what we call adjustment of status applications. Now, every year, 500,000 people get a green card through what's called an immediate relative, a spouse, a parent, or a child over 21, 500,000. Those immediate relative cases require 2 different forms with 2 alternative forms. So you have to file an I-130. That's the hey, this is my spouse, this is my mom, this is my dad, this is my kid. I-130, right? The I-130 filing fee is going from $535, I think it's up to $680, if I'm not mistaken. So it's going up by 30%. The second part of it is the adjustment of status, the 485, which is going from $1,225 to $1,440. So it's only going up like 15%, except they're pulling the big con. The USCIS has the big con going on here. Because under the current filing fee, you also receive a work permit and a travel document. A work permit and travel document. Under the new rule, the work permit and travel document are no longer included as part of that now $1,440. What? Oh, well, surely they don't charge very much. Well, what they're cutting a break. The filing fee for a work permit filed with an adjustment is only $260. But if you want a travel document, what we call an advanced parole, now $630. And advanced parole takes them at most 15 minutes, probably 12, closer to 12 minutes. They're charging $630. So the new filing fee, and everybody that files for a green card, because it takes 2 years to get a green card, go to their website, put it in Atlanta, 2 years to get a green card for your family. They don't need to work. Their rule, and I'm going to read you a rule in a second. Their rule literally says they don't really need to. That's like that's an additional benefit. That's like a super benefit. You don't really need that. Who needs a work permit? Kids don't need work permits, right? Kids don't need travel documents. You mean other than seeing a dying relative or getting a social security number? Other than that, those essential needs. So the new filing fee for a marriage-based adjustment with a travel document and a work permit is $1,440 plus $260. So now we're up to $1,700 plus $630. So now you're at $2,330. The current filing fee is $1,225. A literal doubling, 100% increase on the backs of newlyweds, on the backs of senior citizen parents, on the backs of children. The USCIS is going to grab your money. Obviously, if you're thinking about filing an immediate relative adjustment of status case, you want to get that filed before. Because they're talking. Money's talking on my watch. They're going to balance their budget on your backs. Now, you would think somebody would sue them over this because it can't possibly be legal to double your fees. Well, I want to tell you, it's even worse than I just said. It's worse. How could it possibly be worse than this? Oh, because the bundling of the adjustment of status, I-45, immediate relative, I-130, work permit, 765, and I-131, travel document, that happened in 2007. Before that, you paid separate fees. But before that, the 2007 fee increase, before that increase to $1,225 for all of those, the adjustment of status form was $380. And the work permit was, I think it was 85. And the travel document was like 85. And the I-130 was, I don't know, 180. I mean, it didn't even, they went to $1,225, which was an increase of everything, but it was a reasonable increase. And what they said about that is really interesting back in 2007, is this, and I got to find the right thing now from where I talk about it here, what their rules said, because it's just fascinating me. This is from 2007. In this rule, DHS provides the 485. Applicants will be half the fine. Oh, that's the new rule. Where's that? Where's the old rule? Oh, come on, Chuck. I had this. Now it's going to drive me crazy that I can't find this really quickly because I had it right in front of me a little bit ago. Let's see. Oh, here it is. Okay. All right. In talking about comments in 2007, the overall size increase of the form from 325 to 1220, from 325 to 905, and then 1225 with all the benefits, was driven by the packaging or bundling of the related benefits with no separate fee. As indicated in our rule, factoring separate fees, applicants typically pay for additional services, which they will no longer pay for. This is the old rule. After consolidating the fees, the fee increase is like 17%. A few commentators at the time suggested that incorporating the fee into the application for these interim benefits would be a good thing. And the Immigration Service says here that most applicants who choose not to apply for a work permit do so because they find the interim benefits almost immediately, which is what they do here. So what's fascinating here is this: the fees collected by the USCIS for EAD applications fund the costs incurred by immigration for issuing the EADs. USCIS incurs those costs for adjudicating, which is a different process. Now, going here as part of this application, I'm going to find what I wrote here. It's just fascinating because they did this because they wanted to save people money, and they thought, and this is underwritten, this is how I read the rule. If we make you pay $1,225, and that includes your work and travel document, but we can adjudicate your adjustment application before we issue a work permit and a travel document, which back in 2007, they were taking they had a 90-day rule, and they did, in fact, do many adjustments in less than 90 days. So they could actually make money because it only costs them, presumably, $500 to actually adjudicate an adjustment, and they won't even have to do the other work. Now, what's happened in the interim 17 years is that the Immigration Service has become wildly mismanaged, incredibly incompetent in their management and how cases are assigned and how processes are adjudicated. It's become way beyond the pale of how to effectively and security-minded way adjudicate these cases. So now they don't want to include these fees because now they say, we're spending all this time adjudicating EADs where people don't even really need them very much. What do they need them for? They don't really need them. We're adjudicating advanced paroles in a year for EADs, in a year for advanced paroles. And so what they want to do now is not be burdened with having to do that extra work and make you pay money for it. So basically, it's the exact opposite of what they were arguing before. It's complete 180 with no legitimate explanation about why they're changing their minds. So Are they going to get sued? You are damn right they're going to get sued on this. So we're looking at that litigation right now. It is it's shocking to me that the Immigration Service says with one mouth in 07, hey, we're going to do them all together, and then we're going to do your adjustments really fast, and we get to keep the money, to, hey, now we take so darn long to adjudicate your case that we're going to make you pay extra to get that done so you can further fund us our own incompetence. That's what they're saying. I cannot wait to make this argument in front of an immigration judge. This is going to be so much fun. The money grab begins April 1. Now, I will note just one thing on the lottery here. The HMB Lottery is in effect. I have it. It's the HMB. HMB Lottery is in effect right now. It's good. You can enroll in the lottery until March 22. Multiple employers can file for you, but as a foreign national, you only get picked once. So it makes no difference whether 1 or 50 do it. They're just going to pick your name, and then you'll have to pick which one that you go to. So it's a time to get it in. Now, my over-under on this is about maybe 520,000, maybe more. Maybe more people than doing that. But if as like they say in the lottery here in Georgia, if you don't play, you can't win. So get your lottery. Now, by the way, there's other alternatives. If you don't win the lottery, just FYI, there are other alternatives. You might be an O1. You might be eligible for a cap-exempt H-1B. There's lots of interesting work going on in that area. All you gotta do is give us a call. If you want to find out more about these things and how to maximize your ability to immigrate to the United States, you know who we are, and you know how to reach us. Of course, you can email me here. Pretty easy. You can call here, and you can also see me on the Twitter machine. Let's take a look at some of the questions here. We only got a few questions here. I've had deferred action issued various times through DHS. USCIS has failed to issue your work, but did you apply for a work permit? I mean, so you have to, deferred action doesn't come with a work permit automatically. You have to apply for the work permit. You have to put the application in with for example, your U visa. So if your lawyer didn't do that, you need to do that. You need to apply for the work permit. That's part of the application. Lucero, hello, Attorney Cook. My uncle has an I-130 from March. Yay! That's like a miracle. His wife's a U.S. citizen. They want to know if you can file for him. He had a criminal charge up 50 years ago. Transferred to the court. Never did. Oh, so he has a deportation order. All right. So 1, does he have TPS? 2, does he have a criminal conviction? 3, was he here in December 2020, December 2000? All those things. So the question is, has he done a FOIA? Have we got a copy of his file? If he didn't go to court, why didn't he go to court? Basically, you need to make a consultation so we can get all these questions answered. Immigration is not just filling out forms. Immigration is wildly complicated, which is why we do consults, because it takes time to look at all the documents, get out all the information, and then give you good, solid legal advice. Sometimes with which the answer is no, we can't help you, but we'll tell the truth. Can you please explain 601K update with the submission last week? I was not aware, Hayes, of any 601A submission. I know what you're talking about. The government did submit. What the government did, the court asked to be alerted if any other cases on 601As were filed in the district. And the government just alerted them to that. It's a nothing burger as far as our case is concerned. Natalie, great to see you. Any advice for marriage? Basically, that's a document which prevents involved. Interview was back to 3. Wait a second. You don't need a 601A if you're adjusting. Why do you have a 601A? Do they have a 601 fraud pending? That's not 601. And the officer adjudicates a 601. So Natalie, you generally ask very clear questions. There's something going on here that is not kosher. They're not right. Yes, you apply. You apply for a work permit. You have your receipt notice, and they have it adjudicated. Call me. We will sue them. We will get your work permit in 60 days. I promise you, we will get it in 60 days. We're going to stick with local field officers. Accredited reps cannot file the mandamus. Well, we can file the mandamus. Have them hire us. That's what we do. But Annalie, your question doesn't make any sense because an adjustment of status applicant does not need a 601A. That's only for consular processing. Diana, hola abogado, yo metí aplicación de familia con mi esposo y ya fue aprobado. Solo estoy esperando la cita en mi país para regresar a su sitio. Well, Diana, ¿usted necesita perdón? Si necesitas perdón, o estás afuera del país, necesito más información y, por supuesto, ¿cuál país? Lucero, you are welcome. Mr. Potential, thank you. Call me. All you got to do is you call this number right here, and they'll help you out. They'll help you out. Let's go down here to Natalie. No, 6 we filed prior to AP. Terminate it. Just withdraw it. It doesn't have to be adjudicated. Just withdraw it. That's easy. Send a letter and I withdraw it. Thank you very much. Boom. So problem solved. They don't need to wait any more than that. And send a copy to the officer. Case has been withdrawn. We don't need it. Thank you very much. Please adjudicate the case. Easy peasy, lemon squeezy. Boy, I was on a rant today. Man, I am so jazzed about suing the USCIS on their fee rule. I just can't believe that. You think everybody started practicing law after 07? I mean, there's a reason I have gray hair, for goodness sakes. It's not because I have a daughter. Really, she's awesome. Yo necesito decirle, perdón, well, no esperes por la cita. Tiene que decir perdón antes. Diana, llámame o llama a su abogado. Right, I think we just got stuck. Oh, yeah, well, it may just be immigration's run. You know, most of the officers are great. I mean, I don't have any problem with a lot of the officers. I mean, there's a bad apple, there's bad lawyers, bad paralegals. I mean, there's bad people everywhere. But for the most part, 98% of the people at USCIS are terrific, the officer level. But the management's incompetent. I mean, that's the problem with USCIS, not the officers. If we let them free to do their jobs and give them proper instruction, they would pound this stuff out. But too much mismanagement, micromanagement, and incompetence from the management level. That doesn't help. Anyway, it's great to be with you guys today. I'll be back next Wednesday at 1 o'clock. I mean, I try to do these every Wednesday, every other week in English, every other week in Spanish. And of course, I can speak either language, either time. And we do this on our YouTube channel. We do it on our firm's YouTube channel here, Cook Baxter. You like the logo back there? Pretty cool. Nice room. We do it on our Facebook Live. We do it on my LinkedIn. We do it on my Twitter. Natalie made a note here that the little move forward on unskilled. I know we had like a dozen people become current as a result of that movement. So it's good. It's good. And I know you are waiting for yours. Hey, everybody, great to be with you this week. If you have any questions, you give us a call. We are going to be happy to help you in any way. And we will see you next Wednesday at 1 o'clock. Thanks a bunch.